attending this session. K&S Partners, founded in 1994 as a three-member team, the firm today has over 110 IP professionals and an overall strength of over 250 pan-India. They have offices at Gurgaon, Bangalore, Mumbai, Chennai, and Hyderabad. Their practice areas include copyrights, designs, patents, trademarks, geographical indications, litigations, and many more. Before we get on with the speaker presentations and the panel discussions, I would like to take this opportunity to introduce to you all our special guest speaker for this evening, Ms. Meena Nagraj, IAS officer. Ms. Meena has over 25 years of diverse experience across the government sector and the financial services industry, majority of them in senior leadership roles as an Indian Administrative Service Officer and formerly as a Karnataka Administrative Service Officer. Meena Nagraj has led and managed varied projects and portfolios which are large in reach, scale, and impact, including Swachh Bharat, rural water supply, and urban and rural development. In her role prior as director of Treasury, she has ably demonstrated a strong focus on government budgets, finance, audits, and controls, which are well balanced with able governance aimed at full accountability and transparency. Currently, Srimati Meena Nagraj CN is the Director Electronics IT BT and also the Managing Director of Karnataka Innovation and Technology Society, referred to as KITS, KITS. She is spearheading the implementation of various schemes and programs of the department in the sectors of information technology, biotechnology, electronics, animation, and gaming and startups. She is ex officio Managing Director of KITS. KITS is the implementing arm of the department working for the promotion of IT-enabled services, ESDM, startup, BT, AVGC sector in the state of Karnataka. Srimati Meena Nagraj has earned bachelor's degree in psychology, economics, sociology from Bangalore University and master's degree in psychology from Mysore University. So without further ado, ladies and gentlemen, on behalf of the IACC, I request Ms. Meena Nagraj to deliver her special address to our August gathering. Thank you very much, and over to you, Ms. Meena Nagraj.
Thank you so much. Thank you for all the profile that you read. And believe me, I'm not a technocrat at all. I'm a generalist, which says it in my degree, but had an opportunity to be part of various tech projects, inadvertently being put into thing. But amongst these august guests, good evening to all the audience members of the event today. I would first likely to thank the IACC team for inviting me to be part of this exciting event where the topic of discussion is software patentability, protecting inventions on latest technologies. We all can agree that given the current scenario, innovations and inventions have become daily news, and we could not be prouder of our ecosystem and its growth. It thus becomes very important to ensure entrepreneurs and innovators feel protected and safe of their inventions so they can focus on inventing and making this world a better place to live in. It is my firm belief that intellectual property is the backbone of a competitive Indian economy. India, over the past few decades, has always encouraged innovation with its own systems of fostering creativity. No wonder India was quick to grasp the modern concept of intellectual property rights as it emerged towards the end of 19th century. Currently, India has been ranked 40 among 53 global economies on the latest annual edition of International Intellectual Property Index. And definitely we need to do a lot more. Patentability has a vital role in all sectors and has become a crucial factor for investment decisions by many companies. We are the largest producer of feature films in the world. Sale volume-wise, our music industry is second only to US. So patentability in the design and creative industry sector has been growing. Our pharmaceutical industry is vibrant and growing with huge investments in IP resources and a number of patents to its credit. Naturally, medtech patentability has seen some good growth. Our university and research institutes have also started acquiring patents on their innovations. As one of the world's most innovative and creative economies, a unified intellectual property framework supports India's competitiveness. This is especially true of many of India's most highly regarded sectors: technology, advanced manufacturing, biopharmaceutical products, and creative content. With the advent of intellectual property regime in India, central government and state governments have initiated several schemes, policies, and programs for increasing awareness for patents and extend assistance to the educational institutions, government organizations, startups, etc., in protecting their intellectual property works across the country. Some of these schemes and programs work with the assistance of professional IP practitioners who are empaneled in respective departments, program, or schemes, while others provide monetary assistance to startups, inventors, institutions, etc. Startups play a key role in promoting innovation and economic growth. They do this by contributing to new business ideas, capital formation, and increasing employment generation. Identification and protection of intellectual property is indeed very crucial for startups to safeguard their unique products. IP plays a vital role in facilitating the process of taking innovative technology to the marketplace and enhancing the competitive of technology-based enterprises. The driving force behind a startup is a novel idea. Putting the idea into practice successfully is what transforms small startups into multi-billion dollar companies. For any startup, registering an IP is essential, where intellectual property laws can protect those ideas and concepts that underpin a startup. A major part of competitive advantage and attractiveness to investors is how well defined and well protected the IP is in the startup's portfolio. In this way, IP is an asset to the new company, thus enhancing commercial value. As COVID-19 pandemic has hit the world, and especially India in a hard way, we need move from a recovery to growth. This will depend for a large part on the new ideas and new knowledge. Karnataka, home to some of the world's big names in research and innovation, is upping its intellectual quotient and making a dash for gold in patenting. To support IPs, Karnataka government has a policy of patent reimburse incentives for startups. The policy defines the cost of filing and prosecution of a patent application. Processing of patent application will be reimbursed to the incubated startup companies subject to the limit of rupees 2 lakh per Indian patent, and to up to 10 lakhs would be reimbursed for an international patent. Recently, I attended the virtual launch of a web portal created by the Center of Excellence of Internet of Things, Government of Karnataka. This portal has been set up to help our startups promote their innovation and make it user-friendly for relevant stakeholders involved. The portal has a simple interface to help startups access information on patentability and quick FAQs to help them ease their journey. Thanks to IP, we create jobs and bring innovation and innovative products and services to consumers and company. With these words, I would once again like to thank IACC for giving me an opportunity to speak today. I look forward to an interesting session. We also welcome further interactions with the industry and academia on this topic. And we also would be glad to lend our support for furthering patentability in our state and our country. Thank you once again.
Srimati Meena Nagraj, thank you very much for sharing your thoughts and perspectives, especially on the topics of patenting and intellectual property, and especially in your role in the Department of Electronics, Information Technology, Biotechnology, and Science and Technology. We truly value your inputs, especially from the perspective of the state of Karnataka. So thank you very much for being here with us this evening. We understand you have a very busy schedule, but in spite of that, you were kind enough to participate in this webinar and provide us your opening thoughts and comments. So once again, on behalf of the IACC, we wish to thank you very much. Let's move on with the rest of the proceedings. May I now request Chandrakant BN, Vice Chairman, Indo-American Chamber of Commerce, Karnataka branch, to kindly take the proceedings forward by introducing the moderator and others. Over to you, Chandra. Thank you. You're on mute, Chandra.
Thanks a lot, Shyam. Welcome to all of you Since I'm from the IT industry, I thought that I could, share a very quick perspective of the history of the IT industry in India and what it has brought to this country, and then, sort of set the context for this session. I think we all realize that if until the 80s and 90s, how India was perceived in the world stage, it was largely seen as a very poor country and a developing country rather. But this IT industry, what it did over the years in the last 2, 3 decades, is really changed that game for us. It's really brought us to that world stage and given us a stage or seat in the global trade. It all started in the 80s, perhaps with the founding of TCS, and then in the 90s, we saw Texas Instrument being one of the first foreign companies to come and set up their operations here in Bangalore. And we also started seeing the whole maturity of the internet. Internet was just coming up, and it started to come, it started to mature in the Indian market, and that gave an opportunity for a lot of new businesses to mushroom here, and the whole onshore, offsite, and global delivery model started to take place. Between 2000 and 2010, we saw the Y2K in the early days, and then the dot-com and dot-com buzz, stock market crash in the US. All this actually created huge opportunities for the Indian IT industry with a lot of outsourcing that happened from the US and other parts of the world. And both IT and ITS, IT services, ITES, IT-enabled services sector started booming in that period, and we saw a number of companies mushroom and grow during that time. 2010 onwards, we started seeing more of American companies set up their own large captives, which later started to be known as GICs. I don't think there's any other industry which has created so many jobs in the for the middle class in this country, and the sector directly employs over 4 million people and indirectly supports an additional 12 million jobs with other sectors booming like education, with engineering colleges mushrooming, with transport, real estate, etc., etc. So the current revenues is roughly about,
Chandra, you went on mute.
You're muted.
I don't know how that happened, but can you hear me now? Yeah, so I was just saying that Indian IT industry is currently contributing roughly about $200 billion, about 8% to the GDP. And, we are seeing some phenomenal things happen in the last, decade or so. One of the things that was always a wrap on our industry is that we are very heavily services oriented. We are only building software or helping other companies, other countries, and other companies do better and contribute to their economies and their, innovation, etc. But I think that has changed a lot in the last 10 years or so. We have suddenly seen a huge wave of startups and product companies that have mushroomed in the last decade or so, which has really changed the game for the Indian IT industry. So this has really created a whole set of new opportunities for our country and for our young entrepreneurs in the last decade or so. And we have roughly about 7,000.
It's muted again, Chandra.
Muting everybody, or I don't know why it's happening. It's interesting. Thanks for letting me know. I was just saying that there are about 7,000 tech startups in India, and India is already home to about 18 unicorns. And that itself is showing that, India has started to create value for itself for within the country and building, creating value for the global ecosystem. So this also creates a whole set of new challenges, right? I mean, when you think about
It's muted again. Yeah. Something crazy. Yeah.
I don't know what's going on. So what I was saying is that this has really created a whole set of new opportunities. It has attracted over $10 billion in investments from venture capital just between 16 and 2016 and 18, and over 6 billion has already been invested in Indian startups by SoftBank out of its 100 billion vision fund. So there's a lot of exciting things happening here. And while all this is happening, we also have to be cognizant of the fact that how are we going to protect our IP? How are we going to protect our innovation? How are we going to make sure that all this creation is protected, right? So so that the whole patentability issue is something that has become very, very important over the last several years. If we spoke about 20 years ago, it was really hard to even think about getting a patent in India, and we had to run from pillar to post. But I think that is changing a lot, and our speakers today who are going to come up now are going to talk more about it. And there's a lot of exciting things that are happening, and a company like KNS can help young startups and entrepreneurs, etc. So let me, with great pleasure, introduce our next speaker, and he'll also be the moderator, and he'll pretty much take the rest of the evening forward. And I'd like to quickly introduce him. He is the partner with KNS. He's a partner with KNS Partners. His practice focus is patents, computers, and electronics. He handles patent drafting and prosecution in the areas of electronics.
Chandra, muted.
What's going on? In the areas, he handles patent drafting and prosecution in the area of electronics, telecommunication, computer science, electrical medical devices, electromechanical, and instrumentation engineering. He renders opinions on issues of patentability, freedom to operate, invalidity, infringement, due diligence, and technology trends for clients. He also specializes in filing and prosecuting design applications. He regularly appears before the Indian Patent Office and Intellectual Property Appellate Board in connection with the prosecution and enforcement of patent rights. He's currently has the professional membership with Bar Council of Delhi, and interestingly, he speaks 4 languages. With great pleasure, I'd like to welcome our first speaker and the moderator, Sri Hari SK, partner from KNS Partners. Over to you, Sri Hari. Welcome.
Thanks so much.
You're muted, Shri.
Yeah, I think I think there's some issue in terms of I think it's getting muted for all.
Yeah.
Yeah. Okay. So I really want to thank the entire IACC crew for hosting me and allowing me to kind of present the Indian scenario with respect to software patentability. So I'll quickly jump on to my slide decks. It will be kind of 4 or 5 slides I would like to show. And just to take it forward, Chandra, thanks so much for setting that context in terms of how IT industry kind of for last 20 years, how they have shaped Indian economy and how they are doing now. It has been really good. And just want to kind of add on saying that a lot has changed in terms of software patenting in India now. A lot has changed. I just wanted to show you how and where are we currently in terms of software patenting. I hope the slides are visible.
Yes, Sri.
Yes.
Visible.
Yeah. Do let me know in case if the slides are not moving so that I can do some arrangements again. So I would like to first of all touch upon some of the success stories from the Indian side. We always hear a lot of success stories about any patents that has come from abroad, but just want to showcase one success story from Indian side now. And this is not from the software side, but still just wanted to showcase it to everyone. So here we have a very big Indian pharmaceutical company called Biocon. Everyone must be knowing about them. And 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 if you see its founder Kiran Mazumdar, she attributes her success, her company's success, to innovation and well-protected IPR, intellectual property rights. And let's see what this story was and how IP helped them as a tool to reach wherever they are today. So they started in 1978 as a pharmaceutical company, and one of the milestones they achieved was in terms of inventing a fermentation process in 1990s, and which they filed a PCT application, which means a patent cooperation treaty application in the year 1999, and eventually they filed national phase application at EPO, which is European Patent Office, and got a grant in the year 2005. As soon as they got a grant in the year 2005, that something changed their perspective in terms of how they see patent as in terms of a tool uh, to make to protect the innovations and use those innovations to kind of further fuel companies' growth. And then they owned two subsidiaries, and they ensured that those two subsidiaries are only meant for research and development. By 2008, they started filing more applications, and they had one interesting story in terms of their patent for insugen. And insugen here it means an insulin, where they could see using patent information through landscape analysis that there's one particular element which is yeast, a specific yeast form, which can create insulin, and nobody had patented it. In fact, nobody kind of even thought about it. So they encashed on this particular information, and they filed a patent application on this, and that became their one of the most famous products called insugen. And and after that, there's no stopping back, and they started filing hundreds of patents throughout the world. So that's how we could see how Biocon kind of encashed on their IP, a strategic IP policy, and they still are one of the good patent filers both in India as well as abroad. Here are some of the trends as to how India is doing in terms of filing of applications. So now we see in a year, we roughly get around 56,000 applications. 5 years back, it was just 42. The growth has been tremendous. And in terms of number of applications being examined, as Chandra was mentioning that earlier things used to kind of a lot of delay was there in terms of examination. Uh, 5 6 years back, it used to be roughly around 20,000 plus applications, and now we are roughly touching around 80,000 applications a year. So examinations are taking place in a great speed, and equally we are able to see a granted ratio for those examined applications, that is touching around 25,000, and the disposal rate overall is 56,000 applications. So that's where India stands, and this change, I would say, has started probably from 2008, when there was a new controller general who took over, and after that things started getting streamlined at the Indian Patent Office. After there was a new government in 2014, they started linking a Make in India campaign to IP, where they felt IP, especially patent, is quite important if some company wants to set up their manufacturing unit or plant in India. So hence they started expediting things at the patent office level, and that's where we could see a lot of change. And internally within the patent office, lot I would say it's a metamorphosis change. It has a complete change where the entire process has been online now, and I don't think so there's even any physical filings happening now. I doubt. And all the communications are happening through online, through email correspondence, and in fact even the hearings are taking place virtually. I'll just touch upon all those points later. Have few more slides to show. In terms of examination rate, when I started the practice in the year 2006, I found that it used to take minimum of 6 to 7 years to get an application examined, and further 2 years to get it granted. But now if you see, this is a dynamic online portal which shows that examination has already started taking place for applications which has been filed in the year 2019 and 20. So that's a great development. And I have, so here is a grant ratio. As Chandra mentioned, that sometimes patenting could be a challenging in India, especially software patents. And also, Sham, in his opening remarks, he mentioned whether a software is patentable or not, whether an algorithm is patentable or not. I think that question is getting settled now. In It's not only India but throughout the world, a pure software code instructions are not patentable. Not only in India, in every part of the world, it's not patentable, including algorithm. A pure algorithmic steps are not patentable, provided those software and algorithms are being applied for some idea and we are able to provide some technical.
You're muted, Shri.
Yeah. So any combination of hardware and software is a patentable subject matter. That combination can have inherent algorithm to it or inherent code to it, but that's okay. But we just can't protect pure software codes or algorithms. However, things were not that great or simple in India. All this started in the year, I would say, 2005, uh, or slightly before that, I would say 2002, where there was a new provision introduced in the law saying that a computer program per se is not a patentable subject matter. Then in the year 2004, there was an ordinance to clarify as to what that per se means. But still, we didn't get any kind of clarity there, and that ordinance was the ordinance didn't came into force, and we went back to 2002 model saying that still a computer program per se is not a patentable subject matter. There's only one clarification um, for the term per se in a joint parliamentary committee report, which says a software program which is ancillary thereto or developed thereon. This is the term used in the joint parliamentary committee report. A software which is ancillary thereto or developed thereon comes out of the purview of per se. So that does not remain within the purview of per se. Those software which are ancillary thereto and developed thereon can be a patentable subject matter. But then what ancillary thereto and developed thereon and how a software can be defined as ancillary or developed thereon, nobody knows it. Even still today, there is no clarity for that. Hence, the interpretation was very, very conservative, and Indian controllers could not appreciate much of inventions coming out of software. And we could see a much higher refusal rate before. Once things got changed after 2017, when there was a guidelines passed saying for every software, there need not be a novel hardware attached to it. So that was a great relief for a country like India, where it has thousands and thousands of IT companies operating, and IT companies or software companies need not develop a hardware for their software products, not required. They can still use a general purpose hardware. In combination, if they can produce a technical advancement, that should be sufficient to ensure they get a patent for their invention coming out of software. And if you see the grant ratio starting from that guidelines, which was rolled out in the year 2017, the statistics looks impressive. And if you see that the ratio is somewhere around 15% of refusal in the year 2017-18, and currently it's roughly around 10% now. So which is a good healthy sign. Going further, I think things should improve because now all the appeals will be taken up at the high court level. So we could see more action there and getting more clarity on the software application. Going on to the next slide. And so there are four major buckets in terms of what cannot be patented in India with respect to software. One is, as I mentioned, computer program per se. Second is algorithm, pure algorithm is not patentable. and the business method where there could be any administrative solution for a problem, or there could be a direct impact in the revenue. There could be an organization model, direct profit and loss. Anything which relates to business is not patentable in India. And also, any mathematical formula, methods, equation are not patentable. But if you see the refusal split up, somehow it shows that algorithm and computer program per se gets maximum attention, and that's where still India is kind of they still focus on as to if any application related to computer program per se and algorithm, uh, you will not get a patent for it. But if the solution goes beyond program and algorithm, they can easily be patented using combination of hardware and software and producing a tangible outcome. We also had a very strange situation where India has 4 patent offices, and each patent office used to follow their own methodology, process, and their own way of adjudicating applications. So some patent office used to grant apparatus, some used to grant method, and some used to grant both. And we felt how this scenario is changing now. Is it even changing or not? Quite to our surprise, we found even this scenario is changing slowly, but still we could see some indication, positive indication there, where starting in 2017, people were not that comfortable in terms of granting both method and apparatus. And that ratio has gone up to 77 now, from 74 to 77. In fact, uh, people are now there's one more trend that we could see here, that apparatus claims are now more appreciated, and those percentage has gone up from 14 to 18%. And in terms of method and apparatus, which is now 77, and pure method still remains very low, and that has gone to 7%, and that has gone to 6% from 12%. So that's where we are now. So here are a few practice pointers. Each one kind of I would suggest people to know before they file any software applications. One, that we should provide a clear technical solution. We need to highlight that. That can if you can kind of highlight it through by way of an example or some statistics in the specification, that will really help getting your application grant by showing a real world effect. For example, there could be a lot of noise in an audio or a video, and we use a filter to filter out all the noise from the data, audio or video data. If you understand, the filter that we use is not a physical filter. It can't be a physical filter, but it's a software. It's an algorithm that we use to remove the noise from the other data. And if that software, if we can show that it's not a software which works in isolation, but it works in combination to provide this a clear audio or a video, that can be attributed as a real world effect, and it will be easy to get a patent for that. Secondly, more and more we've put hardware limitations in India, it's easier to get it along with physical interactions. Physical interactions here means, for example, there could be one mobile which could be interacting with a server, and that server could be interacting with another entity in the network, and that network can reply back to the server, and server could reply back to the mobile. So these are the interactions. If we can show these interactions in the specification and claims, it will be helpful to get a grant easily. And it's better that we use uh, more and more hardware features like field programmable gate array, specific integrated circuits, processors, memories. It's all good to have those in place. And something that we should need to avoid or be careful about is something called a functional claim, where hardware cannot just recite action or functionality of the apparatus. It should also contain what are those constructional features within that apparatus which make it new and inventive. And it's always preferred not to use words such as program, software, algorithm, instruction, codes, any business examples. This is always better to avoid, because we have seen if these are part of the specification, controllers get prejudiced and they may take a very tough stand. So it's better to avoid those. And also not to stress more on software implementation part in the specification, rather go for a combination of hardware and software. Um, I gave a brief overview of this in terms of where IP landscape is there in India, but still just to kind of touch upon it again, that Indian Patent Office went through an overhauling and the entire IP process was streamlined by way of paperless office, automatic issuance of patent certificate, which we call latest patent document. All the video conferencing, all the hearings are through video conferencing now. Even multi-party hearings are taking place where more than one person can join from different locations. And the government created an IP cell, and they also had a first IPR policy the new government came up with. In fact, I could see a kind of a sea change even when I interview some of the youngsters from straight from college saying that, sir, I have already filed a patent application, so I'm interested in getting a job in patent, which I couldn't see 10 years back or 5 years back. So that's a great shift where, in fact, new government has installed a lot of tinkering labs, both at the school levels, colleges, so that they can get used to real world problems and they can provide solutions to it and also take advantage of that. Further, the electronic filings have gone up. I have put in 90% here, but I think it's around 97, 98% now. And reduction in backlog is significant, where earlier, if I say that it used to take around 8 years to get a grant, now it's just 2.5 years to get a grant of it. And the disposal rate has increased tremendously. And we have seen applications getting examined in 2 to 3 months time itself and getting a grant. So that's all I had to kind of present. In case if you have any queries, please do let me know. I'll be happy to kind of explain it further. Moving further, I would like to introduce you to my colleague and friend, great friend from A. Thornton, London, and his name is Nikesh Patel. Nikesh is a partner and he is a UK chartered and European patent attorney in the electrical engineering, electronics, telecoms, IT department, and has been practicing in the field of intellectual property law for over 15 years. Nikesh has specialist expertise in computer systems and electronics. Nikesh directly advises UK and overseas clients on patent matters, including identification of patentable subject matter. Nikesh has drafted and prosecuted patent applications in a wide varieties of technology, including computer implemented inventions, in which he has considerable experience in advising on the threshold of patentability in the UK and Europe. He also provides strategic advice for SMEs and large multinationals and manages worldwide patent portfolio for his clients. I would request Nikesh to please kind of present his slides. Thank you so much.
Thank you, Srihari. And thank you all for the IAC for the opportunity to share my insights and thoughts with you. And in an area I'm very passionate about and have a great interest. I'm going to share my screen now. Hopefully that works so I can share the presentation. Can you all see that? I hope so. Yeah, so I'm just going to, nice introduction from Srihari. He's mentioned my background. I'm a partner at A. Thornton, which is a boutique IP law firm in London. And, you know, we've been around for over 100 years. So, and I've worked in the industry for, as Srihari said, 15 years. But I've worked in the computer implemented invention field since I started. So there's been a lot of changes. And I'm just going to go through some of the aspects of patenting generally, and also patenting software inventions. So if I start with why patent or patent, well, you can use the patents to prevent others from improving their market position and from using your technology without permission. So you can use it you can enforce your patent or even threaten enforcement using a cease and desist letter. The other advantage of patenting is you can deter others, because by having a pending patent application or patent alone, that can be sufficient to prevent others from copying the technology and entering the market. If you have a patent or application, you may wish to seek licenses, so to give consent to others to use your patented invention in exchange for a royalty payment. And the more attractive the patented solution is, the more likely you are to receive these. Don't forget that having a patent does not mean that you are not infringing other patents. So as part of any patent strategy, you will want to consider freedom to operate. You can use the patents that you own to reduce the likelihood of adverse litigation, so as a defensive patent, and to negotiate cross licenses. A strong patent can be useful for securing freedom to operate, for example, by means of a cross-licensing agreement, as well as monetary rewards. The license could simply be a means of achieving agreement not to sue someone. Patents can help demonstrate technical vitality and show that you are an innovative company, because the applicant name, the inventor names are published with the patent. So generally, patents can be considered assets that add value to your business. Now, there may be limitations to patents, as many of you may know. Patents are territorial, so are limited to the country or region in which the protection is obtained. So you'll need to consider where you want to file the patents. As Srihari mentioned, you may consider where manufacturing is taking place for yourselves or for your competitors, and also taking into account your major markets. But obviously there's cost to be taken into account as well. The limitation also, there's a 20-year limitation. So you have 20 years from filing in most jurisdictions, and it can take a while to get patent granted. But the point is that as part of the patent monopoly, you get a limited term of protection in exchange for publicly disclosing your invention, which assists with the innovation. In the software field, this 20-year term may be sufficient because software is consistently changing. And it's appreciated that in certain fields such as life sciences or biosciences, it may not be, because it can take quite a while for a product to develop in that time. A patent will contain claims, and the patent is limited by the scope of the claims. So it's very important to craft your claims appropriately. Some of you will be very familiar with what the effect of a patent is, but I'll just touch upon this briefly. The patent will only allow consented parties to use the patented invention. At least from the UK perspective, third parties without consent shall be prohibited from certain acts, as shown there: making, selling, offering to sell, importing, keeping, and using a patented product, as well as a product obtained directly by means of a patented process. Using or offering or for use in the UK of a patented process is also protected by a patent. So there may be many people in a chain where action can be taken against. You may prefer not to take action against your customers, but by having a patent, your customers may come to you. Now, moving on to the software-related inventions and the EPO, the European Patent Office. The EPO is an intergovernmental organization that as you may be aware, that has 38 European member states, and that includes countries that are not part of the EU, such as the UK since Brexit. The EPO sees software inventions or inventions that are implemented by a computer as a computer implemented invention, and they see that as a key area for innovation. As you'll see, there's a little chart there. In 2020, digital communication was the second technology field of patent applications at the EPO, second only to medical tech, which actually includes wearables.
That's what put me on the track of must get my page.
And computer technology was third in terms of filings.
When I got the call back from the
digital communication and computer tech can be enabled or rely on software. So there is software involved in all these different areas, I believe. And there are a growing number of applications in digital technology fields such as AI, blockchain, 5G, quantum. But many fields can be impacted by software inventions. And as I mentioned, medical technology itself, such as wearables, are one of those fields. Moving to the EPO itself and what they claim as a patent office, they claim that they set a worldwide benchmark. They have an established practice for jurisprudence and law that has been built up over the years. They say they have predictability and legal certainty, and they have a harmonized approach to it, assessing patentability across all technical fields. And from my experience, I think I tend to agree with that. I mean, obviously there are cases where you disagree, but generally it's quite a patent office you can probably rely on and learn from, actually, I think. Patenting software inventions. So Srihari's already explained a few things to consider and some practice points which are very helpful. But generally from the EPO and UK IPO perspective, there are a number of requirements to be met, which you may wish to consider when deciding whether to apply for a patent application. The first is whether it is an invention. Is your concept an invention in the first place? As Srihari said, there are things such as in India, as well as in the UK and the EPO, there are things that are excluded from patentability, including business methods, mental acts, computer programs, mathematical methods, presentations of information, as long as they relate to that invention as such, or per se, as Srihari mentioned previously. So there's a similar sort of caveat there. And then your invention has to be new over prior art. I think that's generally well known. The invention needs to exhibit an inventive step or be non-obvious. So that will depend on the technical field, on who the skilled person in that area is. It could be a software engineer, a system engineer for software inventions. And the final requirement is it needs to be capable of industrial application, which is normally not difficult to meet. So generally, if you have a non-obvious technical solution to a technical problem, it should be protectable by a patent. But as Srihari mentioned about the per se caveat, what is technical when you talk about a technical solution to a technical problem? Well, the EPO hasn't provided a definition, and the reason being that they want the case law to they know that the term has a different meaning over time, so they want the case law to help define those that term. And so if we look at what technical could mean from the examples given by the EPO, there's examples of technical applications in the legal resources that they provide. And you need to consider whether your proposed invention serves a technical purpose and whether it's linked to the functional program steps of your software. So the pure software, as Srihari said, the pure software itself will probably not be protectable by patents, but is there a technical application or some kind of technical purpose that you can actually talk about and that your invention provides? One of these examples, there's a number of examples, but the first one starting with controlling a specific technical system or process. If you have that in your claimed invention, it's very likely you will pass the excluded matter test, as well as if there's something new in there as well, then there may be an inventive step. Determining measurements from a number of passes of a compaction machine. You then also there's also an example of a digital audio, image, or video enhancement or analysis. So image processing can be provide a technical purpose. Separation of sources in speech signals, speech recognition, that might be very relevant to natural language processing, perhaps. Other examples from the European Patent Office, encoding, decoding for reliable, efficient transmission or storage of data. That can be very relevant to certain types of encoding, decoding schemes. There's also encryption and decryption. These are all fields that are, I think, relevant to the software inventions. Optimizing load distribution in the computer network, again, a computing problem. If you can show that you've got a networking or computing problem, that can help with demonstrating a technical application or technical effect. There's a few others there that might be relevant, including for the medical devices industry, providing a medical diagnosis by an automated system processing physiological measurements. That's been found to be a technical application. And finally, the use of a neural network in a heart monitoring apparatus to identify irregular heartbeats. That's also been found to have a technical application. So that can help you when you're prosecuting or having your patent application examined. But it's important to have this information in your patent application on filing. Another area where you may want to, which can show a technical effect and meet the requirements of technicality, is where there's a technical implementation, and that can be very relevant to software inventions because that's all to do with the code and whether what your software is doing to the computer itself. Is there a further technical effect that is taking place in the computer? So does your invention operate at the level of architecture of the computer? And so if it does, that's a good sign that there may be a technical effect in there, and it may pass the exclusions. Does your claimed invention cause the computer to operate in a new way? And does your invention cause the computer to run more efficiently or effectively as a computer? Now, it's not just sufficient to say you're running a program and it's just a better program, but is there something more that you're doing to provide this efficiency or effectiveness in the computer? Generally, you can look out for certain types of technical effects in relation to processing power, bandwidth, memory, memory access, speed, reliability, or latency. These are all like things that you can look out for when you're trying to explain where there is a technical effect in your software invention. Now, patents, you may think that patents aren't the answer, and that's a fair point. I think you need to take into account when you're thinking about your strategy on whether to pursue patent applications. Are there other alternatives? Well, there are. There's trade secrets. Trade secrets are relevant to the strategy on whether to proceed with a patent application at all. You may prefer where you haven't published details of your invention and you have procedures in place to maintain secrecy. I think it's important to have procedures in place to maintain secrecy. So trade secrets can be appropriate where AI related solutions may not be protectable by patents as they are excluded. So there's no invention there. Well, then you might think about trade secrets. Even if there is an invention, it may not be publicly visible or people may not be able to reverse engineer it. Similar to visibility, if it would be difficult to detect whether someone infringes your idea, your patent, patenting may not be appropriate, although you may be able to acquire this through litigation disclosure later on, but that can be quite a costly process. So if any of those three are met, you may decide not to go for patents, which is a fair strategic decision, I think. But then you do need to consider the drawbacks of trade secrets. A competitor may figure out how your invention works anyway, and they may independently develop the same invention and protect it, in which case they have the monopoly there. There's also the option, instead of trade secrets or keeping something secret, you can publish. You may decide that you want to prevent others from patenting, and something cannot be protected by a trade secret as it's likely to be publicly disclosed when you put it into practice. And so you may decide to just publish your idea, and so it can be citable as prior art against future patent applications by third parties. There's also, very relevant to software inventions, you can make program code open source to enable others to use your tech and become early adopters. Of course, even if you do patent, you can use free licenses for other parties, so they can have consent to adopt your technology. So patents can still be used in that way, but open source may be another option. So I'm briefly going to touch upon patent strategy, which is more generally relevant, so not solely relevant to software inventions. I know we're running out of time. So a company should decide how to deal with third-party patents, and a company should also decide how to deal with their own patents. So third-party patents, you may decide to carry out freedom to operate searches, patent clearing searches to ensure that you're not infringing someone else's patent. You may license in tech. You may decide you want to license in technology, which is a fair strategy. And there's a number of patent pools in existence, especially in certain markets such as the telecoms market and even the automotive market now. Actually, there's a number of patent pools. So you may decide to join those to deal with third-party patents. In respect of your own patents, you may decide to file patents for every invention you come up with. Or you may file more business relevant patents for the particular products that are of interest. You may file patents for potential licensing opportunities. So you may not even be making this product, but there are companies that use that, do the R&D and then license out the patents. In terms of encouraging people or others to patent, what is one way of doing that is through I know a number of companies use employee reward schemes. So inventors will get rewards at certain stages of the patent process. So when they when they provide an invention disclosure to you, they may get some kind of reward, and then when it publishes and when it grants, there's different ways of trying to encourage innovation in an organization. Finally, I'm just going to touch upon filing options. There are many ways to get a patent, but there's different conventions available and different routes. I'm just going to outline the one of the ways of doing it. So you may initially file your Indian patent application, and then you'll have 12 months to file what Ashwihari actually mentioned, the PCT application, which is a convention by the World Intellectual Property Organization, which covers a number of countries, actually 148, but it might be more now. And that's an application where you can just file the application after that 1-year period, and then you'll have 18 months or up to 30 months to decide whether to file in other countries. And then you can decide to file in the European Patent Office, which covers 38 countries, including the UK, as well as any other countries of interest. And you may even decide to file the UK separately. So that's one way of going ahead. If you decide to file a UK initial application first, you can actually request a search. So that's one alternative, but you have to take into account national security provisions. Instead of filing this PCT, if you know where you want to file, you can just file national applications at these various patent offices at this 12-month stage without losing your initial filing date. So you can actually claim back to that first filing date when you file that application. So that's one way, a filing option, if you will. So I'd just like to, I think that ends my presentation, and I'd like to thank you all for listening, and I think I'll hand it back now to Srihari.
Thanks so much, Nikesh. It was extremely helpful.
Thank you.
Thanks so much. So going forward, I would like to introduce our co-panelist, Mr. Raj, CM, and we have Mr. Pawan, Mr. Pawan Kumar. So I'll quickly introduce them. So let's start with Raj. Raj is a Senior Vice President and Managing Director, International Operations at Anthology Inc. One sec. So sorry for this. Yeah. Raj is a Senior Vice President and Managing Director. Raj plays a critical role in expanding Anthology's global footprint, introducing the products to international campuses across Asia Pacific, Europe, Middle East, and Africa. In his previous role at Campus Management, Raj managed operations across Asia Pacific, Europe, Middle East, and Africa divisions and was Managing Director for Campus Management internationally. Under his leadership, Campus Management engaged in some of the largest educational tech implementations in over 30 countries. He is an evangelist on the use of customer experience management solutions across verticals and is often consulted and quoted by Asia and Europe media for his expertise on customer experience management as well as ICT adoption across education. He has consistently advocated the need for greater automation, process management, and leveraging technology to scale education for the developing nations' educational sector. And now, yeah, I would like to introduce Pawan. Pawan is a Senior Vice President, Global Indirect Business at Altair. Pawan is a complete professional and a business leader by nature. Pawan is a dynamic leader, techno-commercial professional, and a sales strategist with a successful track record of delivering profitable growth and building market leadership in high-end competitive environments for global companies. Influencer with high-end product and software service knowledge in engineering industry, ranging from bicycles to rockets. Pawan is currently responsible for Altair's indirect business of Altair's simulation-driven design and data analytics tools globally. He has proven experience in setting up new facilities, divisions, and scaling them up into sustainable and profitable business centers. He has demonstrated excellence in engaging with diverse stakeholders, internal as well as external to the organization, including direct teams, partners, cross-functional resources across product and other functions and customers. He's also been active in various industry associations and is a past chairman of IACC. So we have a great panelist here, and I would like to quickly jump on and kind of start start with Pawan. So Pawan, I could just see from your website, and so there's a powerful statement there. and it says changing tomorrow together. And business is complex, but in complexity, there is opportunity for innovative solutions. So my question is, Pawan, how do you tap innovative solutions within your company, and how do you protect those innovative solutions through patent? So what is a filing strategy that you follow?
Thanks, Jerry. Good question. Uh, we pride ourselves as a company which aids innovation even amongst our customers. So we believe the tools and technologies that we provide actually let our customers innovate and also come up with patentable solutions themselves. Having said that, in the journey of creating these products and solutions, we ourselves have embarked on a patent journey. And just like you have mentioned in your talk, uh, a hardware patent is much easier to defend and get hold of. And we also realized that very early on in our life that if we have a software tagged onto a hardware, we can end up getting a patent. In fact, a case in example is something called Toggled, which was an LED light bulb that we came out as a project out of a sustainable transportation solution project. And we ended up getting close to 25 patents for that. And on the software side, we don't, it is a tougher journey, as you can guess.
Yeah.
And having said that, the process is pretty, I would say, laid out, well organized. We unfortunately don't patent in India because our company is owned in the US. It's all there incorporated in the US. So we end up doing a peer review in India, have a patent review panel in India. If it's a good idea, we pass it on to our peers in the US who do another peer review, and then our internal legal team takes over. And if they consider this worth the effort, I think Nikesh pointed it out very clearly, cost of this whole process is quite a lot. So before you go in for a patent journey, you got to be very clear that you have the right to defend it in case required. So we go through that, and of course, we use an organization quite similar to yours or A. Thornton in the US to take care of the complete filing. So this is the way we handle this, Sherry.
Thanks so much, Pawan. So moving on to Raj. Raj, I see that Anthology has now started writing the next chapter in the higher education side. So how do you believe for Anthology, patenting is a tool for you to kind of to take the pole position?
Sure, thank you. Well, firstly, let me rewind back a time frame a little bit here. And interestingly, we have separate subsidiaries here. One of the subsidiary, Talisman, has been around here for over 20 years, and Talisman is one of those product company standpoint, one of the pioneers of building products out of India and taking the product to global platform. And when we actually started, this was, like I said, the 20-year journey. And you could hear in 2017 is when things got amended. So you could imagine the journey that we were going through much earlier to that. But we didn't lose hope. I mean, we kept actually filing patent, and we file pure software patents. Right? There is no hardware element in our patents. So it takes harder to get those patents. But we actually went through the struggles, and it typically took us 5 to 6 years. In terms of being able to get there. But I think what we learned through the process is quite interesting. I think that is what we carry, that you could use a patent as an offensive business strategy or as a defensive business strategy. So what we effectively, that means is, I could actually, when we went into a lot of these countries and wanted to sell a India-made software, I mean, they didn't have a lot of big name, and we would actually have a lot of resistance. And then when we started using patented, it actually calmed a lot of nerves, because that effectively means I'm bringing something innovative, something that nobody else has thought about. So that's one of the ways, that was like a defensive strategy that we were using, right? I mean, we would say that it's a patent pending, how many patents. So that would actually be a defensive strategy. Whereas on the offensive strategy wise, we would effectively, the key differentiated product offerings that we have would be used in kind of feeding for the RFPs, feeding for the sales processes, feeding those in, so that becomes an offensive business strategy, where once those kind of plugs into the requirements of the customer, you actually have an upper edge compared to anybody else because you're the only one who has a patent on it. So we have used the patents in both offensive and defensive strategy. What we learned, and this will be probably useful for everybody here, is unless you have a culture of, and you understand what it means, because once an employee working in your company actually, they find this out and they file a patent, actually it belongs to the employee. Unless you have a clear understanding that this is, they have agreed to work with the company and the patent belongs to the company jointly, and there's whatever paperwork that we have to do, and Thornton and folks like that, that's what they help you figure all this out, right? So, but that's important to understand the culture within who owns it, how do we actually build the journey, build the culture, at what place, and what is the ROI? What is the return on investment that you drive on a particular patent? Because is it going to make you 100x if I actually go out there and do this? So that becomes very important. So I think, there's a lot, and again, it's a 20 years journey, so I can keep going on, but I think clearly with the AI and ML and everything that's coming up, this is a fantastic time for patenting and doing something very creative.
Of course, yeah, I can't agree more, Raj. Even India has now become an innovation hub now, and we could sense that everyone is bubbling with a lot of energy and ideas, and it's so good times ahead for India now, yeah, and for the world. So over to Nikesh. So Nikesh, especially I often get queries from my clients asking, where should I file? Should I file a jurisdiction-specific applications in Europe, or should I directly file a European application? And that gets kind of multiplied when we talk about the scenario of UK and Europe now being Brexit in place. And how do you see that? What's your take for our clients and viewers?
In terms of where to file, yeah, so it will obviously firstly depend on where you think you're going to need the patent or going to exploit the patent, or where your competitors are based. So that's one of the first factors. If your competitor has a manufacturing plant somewhere in one of the European countries, you will probably want to cover that country. Now, as you say, there are two ways of doing it. You can file national applications, like the UK national application, or you can file a European patent application, which covers 38 member states of the EPC, which includes, as I say, countries that are outside the EU as well, including the UK. So you can file that single application, and then once it grants the European application, it becomes a bundle of national patents. And it depends on where you validate that European patent application as to where it is effective. So you have to pay a validation fee in certain countries. But as I say, it potentially covers 38 countries. The alternative, as I say, is a national application. But the national application obviously is territorial, and it's restricted to that territory. The one thing that you may want to consider, especially for software inventions, is there a difference in the way that the different patent offices handle the type of technology? Now, I would say that the UK Intellectual Property Office are quite strict actually with computer implemented inventions, so software inventions. They follow these very strict rules, and you may find that a lot of your inventions are being excluded because they are related software and computer implemented, or computer program as such, or per se, as you mentioned, Shuhari. Whereas the European Patent Office are maybe less strict, but they do follow similar rules. The thing is, with the UK Intellectual Property Office, your invention may be excluded from patentability, but at the European Patent Office, you'll get past that exclusion. If you introduce even a computer into your claim, that will get past the exclusion at the European Patent Office. But you may be faced with an inventive step objection, because what the European Patent Office will look at is, where is your technical contribution here, and is that in a technical field, and what technical problems are you solving? So even if you've got the computer, you still may be faced with an inventive step. Whereas at the UK Intellectual Property Office, inventive step is maybe not as strict or as difficult to get past as the EPO. So once you've got past the patentability requirement at the UK Intellectual Property Office, you may have an easier ride to get your patent granted in relation to novelty and inventive step. So there's two different ways that the patent offices look at it. The UK IPO, Intellectual Property Office, say that you'd always end up with the same result. So if an application is refused at the UK Intellectual Property Office, they say that the EPO would probably eventually refuse it anyway because it lacks an inventive step. Now, there aren't many examples of this. They're actually requesting examples to prove their point, which is quite interesting. But that's what they say, and I would say that there are differences, and they slowly are converging. I think they're getting there, and they're all providing, for example, in the field of AI, they are actually set out public consultations. So they're trying to get stakeholders' input on how to handle these inventions. And I think the approaches are slowly getting closer and closer. So you may find eventually that you don't really have to decide, and they'll come up with the same result, regardless of where you go. Bear in mind for EPO, if you go for national application, if you go for the EPO application, you can file it in English, and it covers a number of countries, and you don't have to translate it. The application, unless the country that you validate in eventually after grant requires it, but there are quite very few that require that. Whereas if you file national applications, such as German applications or any other applications, you do have to translate them. So think of those, there'll be costs associated with that as well.
Thanks so much, Nikesh. Yeah. Nikesh, I'll just come up with the other question later on. So Pawan, I got very curious when I saw your LinkedIn profile, and I thought I should kind of pose this question to you. I saw the tagline in your LinkedIn profile saying that, "What will you innovate with the power of Altair?" Okay, and that's quite strong. So I want to link it to Raj's statement of innovation culture. So what do you think, and how do you see innovation as a culture and protecting your innovations within Altair? How do you see it happening in Altair?
Well, when you want to help other companies innovate, you obviously need to be very, very innovative yourself to come up with products that can do things which other products can't do. And they're very technical in nature also. So I think it all starts with what you mentioned. We have, and Raj also mentioned this, we have used it both as defense and offense for making sure our products remain on the top of the stack. An example of I would say, a very different type of patent is the way we license our software. We have a very unique way of licensing, which we patented. And that took some effort actually defending it. But we did get through, and after a four-year journey, now we have a patent which other companies have tried to emulate, but they cannot copy. They can only come close to that. And we have quite a lot of competitors in this space, in the software simulation space, as we call engineering simulation space. So that does happen. And a defensive strategy that we used was actually to embark on a manufacturing journey to help make sure that our R&D patent can be defended better. This was for the LED tube lights project. So we set up a manufacturing plant, a lights out manufacturing plant, very small scale in Detroit, using an old, car company. Obviously, many car companies have gone out of style there. So we used that facility and set up a manufacturing thing. And now we were able to defend, and we have licensed the technology consequently to other LED majors. So it's kind of all sides of the coins, really. I don't know where to stop, and I'll stop here.
Thank you so much. Yeah, that's sufficient. That gives the flavor, of the culture within Altair. Raj, I also saw something very similar for anthology, and it says that advancing knowledge for its clients. Internally, how do you advance knowledge, and what are some of your success stories of IP? If you can share it for our viewers, it will be helpful. You're muted, Raj.
I'm sorry. Yeah, so I think, if you think of this education technology as a space, you can think of what has happened in the last 2 years. Right? 1.3 billion students are effectively out of schools, out of class. Right? And if you think about an industry that actually has taken the biggest thing, you can put education right up there on the top. So that has been a huge change. So what this has done is you have to evolve. Right? There are things like synchronous learning, asynchronous learning. There are concepts and new thoughts that have actually come in. blended education, blended learning, flexi models. In every one of these ideas is patentable if you do it right. Like a flexi model, which is how many classes you take online to how many classes you take in your offline classroom, to how that math work in terms of your credits, how you earn. That's an example of how you can patent something. So all of these, actually, you can use your creative brain. I mean, there is ideas, right? But then we have to commercialize these ideas. So that's where the big, thing comes from. I mean, is this flexi classroom big enough idea that you can multiply this, 1,000 times? And that's where we actually apply our heads in figuring it out. But I think bottom line, if we in an education technology space, this is a perfect storm for us, right? Where the world has created the platform for us where we can innovate our way through it, find patents and get on the offensive, because everyone is looking for a new way of teaching and learning. So great time for us in terms of patents.
Excellent. Good to know that, Raj. Yeah. I wish you all success on that journey. Yeah. Over to Nikesh. So Nikesh, there has been a lot of questions in terms of examination standards for UK versus Europe. What is the difference? Where do you see a demarcation, and what should be the approach?
So yeah, as I mentioned earlier, there is a slight difference in the way that the UK Intellectual Property Office may examine software inventions,
And I
computer implemented
also,
inventions.
Nikesh, sorry to stop your flow. I'm so sorry. I also have one anecdote to kind of add on to that. Indian Patent Office earlier used to conveniently follow either UK approach or European approach, whichever was tougher for the applicant.
Okay.
So probably they used to tend to go with UK wherever there was a refusal. So just thoughts on that. India is not anymore that way, but yeah.
Yeah, that's true. Yeah, so they do rely on those systems, and the UK are quite, as I say, they're quite strict in terms of exclusions from patentability and computer and program inventions. So if there was a pure computer program invention, I would probably advise clients to go for the European Patent Office, actually, because I think they may be more willing to accept the arguments in relation to computer implemented inventions, whereas for AI inventions, I've noticed recently the EPO are now developing their standards for that, and there's new case law in relation to that continuously. You may find actually in some cases simulation and actually image processing and simulations ideas may be more patentable in the UK, because there's been a recent case at the EPO in relation to simulation patenting, where they've taken quite a strict approach in relation to simulation patents. Pavan, your strategy may change, I don't know, but in terms of for your company, because you said you're involved in simulation, but this new case now says that if you're simulating something technical, that doesn't matter. Even though the thing you're simulating is technical, that's not going to be taken into account for your assessment for patentability. So you may find that it might be better to go for the UK IPO for those types of inventions, for example, because of the they don't follow that approach. Basically, they don't follow exactly the same approach to the European Patent Office. So for those type of inventions, we may be advising clients to look at the UK and maybe national patents.
Thanks so much, Nikesh. I wish I could have asked one more question to all our panelists, but we are running out of time. I'll quickly jump on to Q&A, and I'll start reading out questions from the chat box, and I'll pass it on to the relevant panelists who would like to answer that question. So, Aishanya, I just wanted to check. I am not able to see the full chat box. Anyways, I'll just start from what I have here. So one is from Mr. Madhu K. The question is there any possibility of getting grant for novel software application which gives a technical advancement over the existing mechanism? If yes, what is the best way to present? Specify such an invention in the draft to have a high probability of getting a grant. Nikesh, would you like to take this?
Yeah, I can take that. I think the answer is yes. I mean, you can get patents for software applications, the software alone, as long as there is some kind of, as you say, technical advancement. Is there a technical advancement though on the computer it's run on? If there's a improvement in the technical implementation, you need to be able to describe that in detail, and that may help you in obtaining patent protection. If you're, as I mentioned in my presentation, if your software is providing some kind of technical purpose or technical application, controlling something or outputting a control signal in a particular technical machine, that can be advantageous in helping you getting patent protection, because that might be considered technical. And I would advise, if you are filing a patent application, to include all that information in your application as filed, in your description, if not in your claims, so that can help you when you are prosecuting your application. But Srihari, you may have other thoughts as well in relation to patenting in India.
I totally concur that, Nikesh. Yeah, I think I don't have anything more to add. I think, yeah, I totally concur. So I'll just jump on to the next question posed by Ganapati Ram. The question is, I have created a software platform which generates application code instantly. Application generates application code instantly for a selected technology stack. Can we apply for a patent for this? So the answer would be, from Indian perspective, yes, you can. Yes, you can file a patent application for this, provided we need to ensure that the entire focus is not on the software code, which performs this application code instantly, but we should also tie it up with what are those inputs which enables to come up to this instant generation of codes, what are the processes involved, and what are those parameters involved to generate those instant codes. I would suggest that if we involve multiple factors, I think we have a good application in hand. Nikesh?
I'd agree with you there. Yeah, you'd want to ensure that you have the technical inputs in there, and what is going on to enable this generation of application code in a particular way. That may have to be described in your application and explained during examination.
Yeah, Nikesh, you also touched upon open source, and there's a question relevant to that from Jayasudan. The question is, new applications built with open source code for certain modules, are they patentable?
Applications built with open source. So, well, yeah, obviously you have to think about, if you're going to exploit that software or sell it, then you need to think about the open source licenses and things like that. But if you've come up with something and it's achieving a function, then you should be able to pursue patent protection, because the patent itself, you're not going to put in the source code in there. You're going to be explaining the functional components of how you're achieving this output. So you won't be adding, you shouldn't be really focusing on the source code, as Srihari had mentioned. So as long as you can describe the functional output or the functional processing that's taking place by your program code, I don't think you need to worry too much in terms of filing a patent application. So if you've got new applications that have been built with open source, as long as you can explain what the open source is doing and how it's working in a new way to achieve it, I don't think that should be an issue. Srihari, again, or others may have other thoughts.
I also request Jayasudan to keep a tap on the agreement that they sign on the open source, and that may have some terms. So have a look at that. So next question is, I would request Raj and Pawan to kind of answer how they do in terms of how they see patentability for any inventions coming out of machine learning, deep learning applications. In Altair and in Anthology, do you file applications for that? There's one question from Jayasudan.
If I were to take that, yes, we do have applications of AI within our simulation tool sets. One of the common exercise that is done in simulation is what's called meshing. You need to mesh a larger component into, let's not get into technicality, you need to do that job. Now that's a fairly mundane task, which is better performed through a automated system, and we use algorithms which mimic your thought process to enable you to do that. And to answer the question on patent, we haven't yet approached that particular problem through a patent area. We believe that's a little too complex to take up and not probably defendable.
Okay,
you can try.
Yeah. So the AI part, we don't actually, we leverage AI tools, but we don't actually build our own AI. But however, on the machine learning, there is definitely a lot you can do, especially on the processes, right? In terms of how you're using machine learning to be able to complete a certain process in a faster time period. So that actually is quite a way to actually think about, because that's a business idea, that's an innovative idea, how you can solve a certain problem. So I mean, that is how we think about the machine learning in terms of how quickly are you training in order to solve a problem faster. So that is what our focus would be. It's not just about building a machine learning tool, right? So that's the difference how we think about it.
Yeah, thanks so much. We are hearing straight from the persons who are involved in it. Thanks so much. So the next question is, how to claims listed in patent applications keep changing as we optimize our solution? How to keep the claims and application up to date? You can't keep on changing the claims. The only way to keep the claim up to date is to ensure it's written broad at the stage of filing the applications, and then probably you can narrow it down based on whatever you feel is relevant for that particular invention as you go through. That's my take. Nikesh, do you have anything else to add?
I'd agree. Yeah, you don't make sure that you have your claims as broad as possible on filing if you want, but you need to also have the text in the application as filed, because you can't add new things into your application after it's filed, really. So just make sure everything's that's relevant is in there. But you should be able to narrow down your claims. But as Srihari says, you can't go really much broader than what you had on the filing, unless you've got basis in your application for doing so. So it depends on how you framed your application, actually. And then if you have different inventions in your application, you can file divisional application, different applications from your original one. So that's another option.
The next question from Jayasudan is, what do you think what to do if we think someone has infringed our patent? Anyway, you have the right to file a case against them, and you can enforce your rights anytime after the grant of the application. And in case if you believe the infringer is ready to negotiate and they are able to, you can have a fair discussion with them, and they want to they want to take license from you, you can do that. If not, then probably you always have the option to enforce your patent through a lawsuit. Yeah. Quickly moving on, how to apply patent in other countries. I think Nikesh showed in his slides by way of something called Paris Convention and also called Patent Cooperation Treaty. You can explore more. You can reach out to us for further clarification on that. Moving on to the next question to Nikesh. If there are two different algos that provide audio compression, will either be patentable, assuming neither are obvious and are using brand new methods to provide the effect?
That's a good, yeah, because the algorithm. That's a good question, because algorithms themselves are not really patentable. But when you apply when there's a technical purpose, such as audio compression, so there's a technical purpose and application there, the steps of the algorithm can now be taken into account to try and work out whether there's a patentability there. So I would say, depending on what the novelty is, if the application is audio compression, I think there's a good chance that you could have two different algorithms that could be patentable. Obviously, it depends on the dates and whether if one was published before the other one, then it won't be patentable. But if they're different, then it should be okay from my point of view. Srihari or anyone else? Sir?
Perfect. Yeah, I don't have anything to add there, Nikesh. Also, the next question is, a question on design patent and user interface. Can you file a design application for a user interface? I hope that's the question from Vikraman. From Indian's point of view, from the Indian patent point of view, you can't file, or it's still under debate that whether a design can be obtained for a user interface. It's still a debatable subject and not very clear, and still it has not opened up for that. But probably in UK and EP, you can get a design protection for user interface.
Yes, I think you're right. That's correct.
Yeah. So moving on to the next question, I think that's from Nishchal. Can we apply for patent on health awareness program? So that program has to be tangible in nature. It has to use some product or a process, and it has to be innovative, and it has to have some technical solutions to it. If it has a technical character to it, you can apply for it and you can pursue. That's my answer. But if it is purely an administrative process and a program, I don't think so. It's a patentable subject matter.
Agree. Yep.
Yeah. I think this is the last question that I have. So I have an idea of software which interacts with multiple hardwares already available hardware like sensors or cameras to collect data and then provides a platform to solve a real-time problem. Can this be patented? Yeah, absolutely. This can be patented.
I'd agree.
Are machine learning algorithms patentable? Algorithm as such is not patentable, but the application of it, yes, definitely is a patentable subject matter. Puneet, assuming chatting has not been invented yet, if WhatsApp now develops a way to send messages over internet through website or app that we know now, will be patentable given the emails have already been invented and basically do the same job, but with completely different user interface. I believe it can be a patentable.
I can answer that. It is possible because there has been something very similar to this that we have patented. It is possible as long as you can show that it has completely different technology or methodology that you're using to save this, solve the same problem, right? And there is merit to it. You can definitely patent it.
Wonderful, Raj. Thanks so much. Okay, that's all from the question answer session. I don't think so. There's any other question there left. Hope we have clarified, though we kind of made it quite fast. In case if you still have any queries, please do feel free and reach out to us. We'll be happy to answer in detail. Thanks so much. Thanks all the panelists, Nikesh, Raj, and Pawan. Thanks so much for your time. Really appreciate and giving useful insights to all our audience. Over to Jose.
Thank you.
Thank you so much. And it was really nice to learn a lot about patenting itself as a concept. I would like to conclude with a quote from Abraham Lincoln, which is very interesting. He says, the US patent system adds the fuel of interest to the fire of genius in the discovery and production of new and useful things. So it is finally the fuel of interest and the fire of genius that come together and help establish assets through patents. So I would like to thank very much our partner KNS and AA Thornton for bringing this together from a content point of view. A special thanks to the Government of Karnataka Department of IT-BT. I would like to start with thanking Ms. Meena Nagaraj, IAS officer, Government of Karnataka, for her excellent inputs right in the beginning, especially about the monetary rewards from the government side for filing patent in India, also international patent. That's a very useful information, especially for startups and others. Also about highlighting, with regard to the Center of Excellence and with the IoT focus on setting up the whole patent office. My special thanks to Shyam, our chairman of IACC Karnataka branch, for starting this event and giving us the right framework as we went off. If India has to become a leader and Karnataka and Bangalore known as the innovation hub, we have to secure our assets and we have to create sources of income which are reliable, and that can happen if there is a good patent strategy. Special thanks to Chandra, who gave the whole history of IT and its related development, of how we have moved from the application side to the product side. And to consolidate that position, the relevance of today's webinar is another step. So we are really happy that our members could gain knowledge from this webinar. I think towards the end, with the last few questions, we were going to the most core elements. Unfortunately, time is less, but my special thanks to Srihari, for moderating wonderfully and getting all the perspectives in. My thanks to Nikesh from A. Thornton. I think you gave this excellent perspective between UK and the European Union, and also at the international scene, how we can go about consolidating our competitive strength and position. Thanks, Raj from Anthology, and especially your feedback on setting up the culture of innovation and creating those internal drivers and gears that help create a perfect and well-oiled machinery for patent generation. Thanks to Pawan from Altair, and you actually gave some examples, even though you were tempted to go to the technical with the concept of mesh and so on. But I think those who are in the thick of things know exactly what you were saying and how they can go on that thin line and find out where the effort versus reward matrix is towards reward while pursuing the patent objective. My special thanks to AA Thornton, and once again to our partner or content partner for this event, KNS. I think without you, we wouldn't have been able to bring this together. In the field of webinars, this is a unicorn kind of field. This concept of patenting, it's one thing to catch on to the bandwagon early so that people can build up their sense and, quoting Raj, have a defensive and offensive position. And I'm sure that in the coming years, people will read in the newspaper about people enforcing their patent right and getting paid for their invention, and tying it back to Abraham Lincoln's concept of the fuel of interest and the fire of genius. So with these words, I would like to thank you all. Thanks a lot to the wonderful participants who have been with us all through, although towards the end the number comes down. Thanks so much for being with us and being wonderful participants. I would like to tell you that you can reach out to Jitika from the IACC branch if you have any specific questions. Please remember that what is yours has to be protected, and only then we can create value. Generally in India, we are running so fast that we may not be having time to protect the track on which we run. So I hope that we take these lessons from this webinar. Thank you so much to all of you, and looking forward to the next webinar, and Jitika will reach out and connect with all of you. If some of you would like as participants to give us some feedback so we can improve, please feel free to do that. And my special thanks to Aishanya and Jitika for all the operational work putting together this webinar. Thank you very much. Have a nice evening, happy Friday, and enjoy the weekend. Bye-bye.
Thank you.
Thank you.
Thanks, everyone. Thank you so much. Have a nice weekend. Bye.
Yeah, you too. Thank you. It was really great session. Thank you all.
Thanks, Jitika. Thanks, Chandra.
Most welcome. My pleasure. Bye-bye.
Bye.
Thank you all. This went really very well. Thanks for all your efforts.
Thanks, Sham.
Thank you, Sham.
Thanks, Aishanya. Yeah. Bye.
Thank you, sir. Bye.